Hi everyone. Welcome to the review video for the surviving spouse's right of election. The right of election includes the forced share and the omitted spouse's share, so we're going to be doing those calculations in this video. There are problems that immediately precede this video, so make sure you have those printed off. There's plenty of space below the facts for you to write all your notes and to follow along and do the calculations yourself. So make sure you have those printed off. If not, pause this video, go back, print them off, and then we'll get started. All right, so we're going to start with problem number one. Tell you a little bit about my setup here. I have my problems and some different colored markers over here. I'm going to try and color code some things for you to hopefully make things more clear. So if I'm looking off over here, it only means I'm reading my notes or grabbing another marker. So problem number one, Arthur died survived by his wife Mandy and their 4 children, Alan, Bradley, Cody, and David. So let's go ahead and write out Arthur's family tree. So we've got Arthur and Mandy, we've got Alan, Bradley, Cody, and David, okay? And Arthur is our decedent. All right, so what we're trying to figure out are what are Mandy's rights in Arthur's estate? So let's read the facts a little bit more and see kind of where she stands. So Arthur's valid will left everything to the American Cancer Society. His distributable estate is $1,950,000. Arthur also had an IRA worth $500,000 with Mandy as the beneficiary, and he and Mandy own their home jointly, and the house is worth $200,000. So let's start with what are Mandy's options in Arthur's estate. The first thing that Mandy can do is abide by the terms of the will. And the terms of the will say everything goes to the American Cancer Society. So if Mandy takes this option, she will take none of Arthur's probate assets, none of that $1,950,000. She'll still get the IRA, she'll still get the house because those are non-probate, but she's not taking anything out of his probate estate. So Mandy's second option is her forced share. And we have a calculation for the forced share, and that is an automatic option. Simply by being a surviving spouse, Mandy has the right to do that. Then we're going to look and see, does Mandy have the option, the third option, of the omitted spouse's share? Right now we have absolutely no facts as to when they were married and no facts to indicate that they were married after the will is executed. So the omitted spouse is not an option, and we're not even going to discuss it. Okay, so let's do some color coding. First things first, the forced share formula. Actually, I'll do that in white. The forced share formula is 1/2 times, we'll do this in pink, Mandy's intestate share. Okay? So 1/2 times Mandy's intestate share minus, I kind of ran out of room here because I'm writing kind of big, minus 1/2 times what she received through non-probate transfers. So we'll do that in green. Okay? All right, so now we know that is the forced share calculation. I'm going to create a little space on my board, so just hold on, and we'll come back and do this calculation in its entirety. Okay, so now we made a little bit of space on the board here, so now we're going to go ahead and calculate the forced share for Mandy in problem number one. And what we have to do in order to calculate the forced share is we have to figure out these two things, her intestate share and what she received through non-probate transfers. So let's start with the intestate share. Taking a look at the family tree, we know that Mandy's formula, had Arthur died intestate, would have been the first $150,000 plus 1/2 because they have mutual descendants. So let's go ahead and calculate that. The distributable estate is $1,950,000. We're going to subtract the first 150. That leaves us with $1,800,000. Sorry about the squeaky marker again. Divide that by 2, gives us $900,000. And we add these two together. That gives us an intestate share of $1,050,000. Okay? So now we know that this is the number that's going to go here. So we've got the first half of our calculation. So we've got 1/2 times $1,050,000. Actually, let's keep things consistent here. Now we're going to subtract 1/2 times her non-probate transfers, or what she received through non-probate. According to the facts, and this is where you're going to find the non-probate information, is in the facts. According to the facts, she had an IRA worth $500,000 that she was receiving from Arthur, and also the home that was jointly owned. Now remember, with jointly owned property between spouses, you only include the decedent's 1/2 of the property, not the surviving spouse's 1/2. So here we have $500,000 in an IRA and $100,000 worth of the house. So that's a total of $600,000. All right. So 1/2 of $1,500,000 is $525,000. And we're going to subtract from that 1/2 of $600,000, which is $300,000. Keeping my colors consistent there. So therefore, under these facts, Mandy's forced share amount is $225,000. And this is what she would receive from Arthur's probate assets if she were to elect her forced share. So now I'm going to erase this, and we're going to do the final calculation on the estate knowing this number. Okay, so now let's do the final calculation now that we know what Mandy's forced share amount would be. So the distributable estate is $1,950,000. From that, Mandy is going to take $225,000, and this is her forced share. She's going to force this amount of money out of the probate estate. So that leaves us with $1,725,000. Now, where does that go? Well, we have to remember that Arthur did not die intestate, so this does not go to the kids. We go back to the will, and now that tells us that this goes to the American Cancer Society, according to the terms of the will. Okay, that's problem 1. Let's go on to problem 2. Okay, we're now on to problem number 2. Okay, let's look at these facts. Ben died last month, survived by his second wife, Allison. Ben's 4 children from his previous marriage also survived Ben. So let's get Ben's family tree drawn. So we have Ben, Allison, and then Ben's 4 children from his previous marriage. So note that they are not mutual children, they are only Ben's children. Let's keep reading the facts because we're trying to figure out what is Allison entitled to. So Ben and Allison were married in 2009, so we know this marriage occurred in 2009. Ben's valid will, dated 5/24/2000, left everything to his 4 children equally. So we know that Ben's will was created in 2000, 9 years prior to the marriage. Looks like we've got the gateway fact for omitted spouse. So let's talk about Allison's options. The first one, for her to abide by the terms of the will. If she abides by the terms of the will says everything to the children. Allison gets nothing from the probate estate. Okay, her second option, forced share. All right, you know the forced share calculation. We're going to go ahead and calculate it out and figure out if it's a good option for her, but 1/2 times intestate minus 1/2 times her non-probate. And then the third option, we've got the gateway fact. They were married after the will was executed, but we have a little bit more work to do. So we are rightful in talking about omitted spouse, but we have to get her qualified or make sure she's not disqualified by those 3 hoops that she has to jump through. So they were married after the will was executed. Then we look to see, were there facts that indicated that the will was made in contemplation of marriage? Did Ben know he was going to marry Allison? We have no facts to indicate that. Second hoop, does the will say it's notwithstanding a subsequent marriage? No, you have no facts to indicate that the will says that this will is valid even if he gets married in the future. Lastly, did Ben provide for Allison outside of the will with a non-probate transfer that he intended to replace a gift in the will? That one's a little bit more questionable. If a court finds that the value of the 401k, the $200,000 401k, was intended to replace a gift in the will, then the court might say, look, you don't qualify as an omitted spouse. But we don't know what a court's going to say, so we're going to go ahead and calculate it anyway. The OSS, omitted spouse's share. All right, so I'm going to erase this, create a bunch of space because we've got 2 big calculations that we need to do, and in fact 3 because we've got to figure out Allison's intestate share. Okay, got a nice clean board here, so we're going to go through the calculations that we need to do to figure out Allison's forced share and omitted spouse's share. Now, we know that the forced share formula is 1/2 times her intestate share minus 1/2 times what she received through non-probate transfers, okay? So the first thing we have to do is figure out her intestate share. Looking at the family tree, we know that Allison's formula is the first 100,000 plus 1/2. So let's calculate that. The distributable estate is worth 900,000. So Allison takes the first 100,000, which leaves us with 8. Whoops. Divided by 2, we've got 400,000. Add those 2 together. If Ben had died intestate, Allison would have taken $500,000. All right, so now we know 1/2 times 500,000 minus 1/2 times her non-probate transfers. This is where we go to the facts and look and see what were her non-probate transfers. So Ben left a 401k worth $200,000 to Allison and a life insurance policy worth $500,000. He left that to the kids. The life insurance policy does not count against Allison, only the 401k. So in this case, the non-probate transfers were $200,000. So 1/2 times 500,000 is 250 minus 100,000, which is 1/2 of 200,000. So $150,000 would be Allison's forced share. But she could qualify as an omitted spouse. So now what we're going to do is we're going to go calculate the omitted spouse's share. I'm going to clear off the board, give us some space. We're going to go calculate the omitted spouse's share and see which one's better for Allison. Okay, now we're going to calculate Allison's omitted spouse's share because remember, she could qualify as an omitted spouse because they were married after the will was executed. So long as the court doesn't find that the IRA, due to its amount, was intended to replace a gift in the will, Allison qualifies. So let's go ahead and calculate it for her, the omitted spouse's share. I shorten it to the OSS. So what's the formula? It's the distributable estate minus gifts to non-mutual descendants. When we say gifts, what we're talking about are gifts in the will. I should probably call that a devise to non-mutual descendants. That gives us an adjusted distributable estate, and then what we do is apply the surviving spouse's intestate formula. All right, now we know based on this family tree, Allison's intestate formula is 100 plus 1/2. We use that to figure out the forced share, so we're going to use the exact same one to figure this out. So let's take a look at the facts. The distributable estate is $900,000. Now we have to look and see were there devises to non-mutual descendants. Ben's will says that everything goes to his children equally. So 900,000 minus everything is 900,000. So that means the omitted spouse's share is 0. There's nothing to calculate the intestate share against. So while Allison might qualify as an omitted spouse, it doesn't really matter because it ends up being 0 anyway. But what I want you to tell me in exam is I want you to walk through the qualifications, say that she could possibly qualify, and then tell me even if she does qualify, the amount is 0, so it is not her best option. All right, I'm going to erase the board and we're going to wrap up this problem with the final numbers. Okay, here's the wrap up of problem number 2. So we know that Allison had the right to abide by the terms of the will, which would have gotten her nothing. The only thing she would have received would have been the 401k at $200,000, and that's a non-probate transfer. But as to the $900,000 in probate assets, Allison would get nothing. 2, we calculated her forced share to equal $150,000. Well, right now that's looking pretty good. So that means of the 900, she could force out 150,000. And then her third option, the omitted spouse's share, we calculated that as 0 as well because Ben's will gave everything to his children. So how does this all shake out in the end? Here we go. We've got $900,000 distributable estate. Okay? Allison is going to take her forced share of $150,000. That leaves $750,000. Sorry about that. $750,000 that will go to the children. So this is Allison and this is the kids. Allison can force that amount of money out as her forced share. Figure out where to write that so it doesn't go off the board. Okay? So that is problem number 2 ultimately, and that's how you would answer it. Now let's go on to problem number 3. Hi everybody, here we go with problem number 3. All right, guess I don't need to say hi to you. You've been here the whole time. I'm just editing. Okay, so here we go. Carl died, survived by his second wife Molly and his 2 children from his previous marriage. Again, start with the family tree. 1 and 2, Carl is our decedent. All right, we're trying to figure out what are Molly's options. So Carl and Molly were married in 2006. And Carl's valid will was dated December 17th, 2000. So the will was made 6 years prior to the marriage. Looks like we've got the gateway fact to talk about omitted spouse. So now let's see what's going to be Molly's best option. We know the first thing she can do is abide by the terms of the will. Well, what will that get her? Carl left $100,000 in his will to each child and the rest to WMU Cooley Law School. Carl's distributable estate is worth $700,000. He also had a life insurance policy worth $200,000 with his children listed as the beneficiaries. And Carl's residence was owned jointly with Molly and is worth $400,000. So, according to the terms of the will, it goes to the children and Cooley, so Molly would get nothing from the probate assets if she were to abide by the terms of the will. So, her second option, her forced share, the FS, we're going to calculate that, half times intestate minus half times what she received in non-probate transfers. And then finally, let's look and see whether or not Molly qualifies as an omitted spouse. So let's talk about that first. We have our gateway fact. They were married after the will was executed. Now, there are no facts to indicate that the will was made in contemplation of marriage, meaning Carl did not know he was going to marry Molly when he wrote the will. There's no facts to indicate that the will states that it is notwithstanding a subsequent marriage. And then we get to our last hoop. Was there a transfer outside of the will to Molly with the intent to replace a gift in the will? Well, all we have right now is the joint house, the jointly owned home. If a court infers, based on the size of that gift, which it might not even be a gift because Molly may have taken part in the purchase of the home, then the court could say, well, look, there's no omitted spouse. But it's pretty unlikely in this case. So we're going to go with the idea that she is an omitted spouse. All right. So before we go to forced share, we know we have to calculate the intestate share. So let's just do that right here on this board right now before I erase everything. So let's look. If Carl had died intestate, Molly's intestate formula would have been what? It would have been 100 plus 1/2. They have no mutual descendants. So Molly's intestate formula is 100 plus 1/2. So Carl's distributable estate is worth $700,000. We're going to give Molly the first $100,000 of that. Leaves us with $600,000. Divide that by 2. We've got $300,000. I'm going to add those two together, $400,000. So we know that if Carl had died intestate, Molly would have taken $400,000 from the distributable estate. So we know that that is part of the forced share formula. So I'm going to use this space right here, so I'm not erasing quite so much, to calculate the forced share. So forced share is 1/2 times intestate minus 1/2 times non-probate. You see I make it shorter and shorter every time. You can do that as long as you know what's going on and what that means. So the first part of our formula is 1/2 times 400,000. And we're going to subtract 1/2 times what Molly got through in non-probate transfers. In this case, the house was owned jointly, which means we only include Carl's share of the house. So 1/2 times 200,000. Sorry, I'm getting pretty close to the edge of the board there. So 1/2 times 400,000 is 200. Minus 1/2 of 200,000 is 100. 200 minus 100 is $100,000. Ooh, squeaky marker. All right, so that's the forced share. So we know if Molly were to take the forced share, it is $100,000. Okay, I'm going to create some space, and we're going to go ahead and calculate the omitted spouse's share. Okay, now we're going to calculate Molly's omitted spouse's share. I moved this down a little bit because I realized I kind of wrote off the board there. So that's just shifted slightly. So when we calculate Molly's omitted spouse's share, we know the formula is to take the distributable estate, and we're going to subtract devises to non-mutual descendants. That gives us, sorry about the marker, the adjusted distributable estate, and then we apply surviving spouses intestate formula. All right, we know that formula doesn't change. It's the first 100,000 plus 1/2. Okay, so let's figure out the first part. So the distributable estate is worth $700,000. All right, we're going to subtract devises to non-mutual descendants, which means we have to read the will. So non-mutual descendants under the will were to receive $100,000 each. So that means we've got 100 for one, 100 for two, a total of 200,000. So we're going to subtract that. These are the devises to non-mutual descendants. Try to give you some correlations there. So now, this marker working. So now we've got an adjusted distributable estate of $500,000. And here we're going to apply Molly's intestate formula. So she gets the first 100,000. That leaves us with 4. This marker doesn't want to draw lines. Divide that by 2. Leaves us with 200,000. Add these two together. That gives us an amount of, I'm running out of space, $300,000. Okay? So Molly's omitted spouse's share equals $300,000. Okay, clean this off. Let's go take a look at the final calculation and distribution of Carl's estate. Okay, we're going to wrap up Carl's estate now. So we know that Molly's options are 1, to abide by the terms of the will, in which case she would get nothing from Carl's probate estate. 2, take her forced share, which we calculated out to equal $100,000. And 3, her omitted spouse's share, which we're pretty sure she'll qualify for, and we calculated that out to equal $300,000. Sorry for the pause there, my notes were wrong. So which option is Molly going to take? She's definitely taking the omitted spouse's share. So how does that work for the rest of the estate? Well, here's how it's going to work. $700,000 is Carl's distributable estate. The children receive 200 of that. So this goes to the kids. Then Molly is going to take 300,000 of that in her omitted spouse's share, her OSS. That leaves us with 700 minus 500, $200,000, and according to the terms of the will, that goes to Cooley. Sorry, Cooley, we got to take care of the family first. So this is the ultimate breakdown of problem number 3. Again, watch these videos as many times as you need to. Let me know if you have any questions. Let me know if you've come up with any problems that you want me to check, and I'm happy to do it. Thanks, guys, and I'll see you in class.